Good morning.
Wait for the case to be called on, Miss Shaw.
Here in the matter of Tower Bridge and HMRC.
Yes, Miss Shaw.
Good morning.
Good morning.
My lords, I appear on behalf of the appellant in
Yes.
this appeal, Tower Bridge GP Ltd, together with my learned friend Mr. Michael Jones QC.
Yeah.
My learned friends Mr. James Pusey, Mr. Howard Watkinson and Mr. Joshua Carey appear on behalf of the respondents, HMRC.
I can tell you, if it helps, that we have read the skeleton arguments, we've read the decision of the Upper Tribunal, and we've read the relevant parts of the gargantuan FGT decision.
They're mercifully set out in the Upper Tribunal's decision.
We also notice that the skeleton arguments do not address the most recent EU cases, notably ZipVit and Chemwater,
Yes,
which we would like to hear argument about.
yes.
And we would also like to hear argument about the status of Chemwater, given that it is a decision of the CJEU given in December 2021 after IP completion day.
Okay. All right, well, I'll hopefully cover off those points as I work through my submissions. So the appellant is the representative member of the Cantor Fitzgerald VAT Group, and the issue concerns the deduction of input tax which was incurred on the purchase of certain carbon credits in the period 18th of May to the 3rd of June 2009 by another member of the VAT Group, Cantor Fitzgerald Europe. Now, the relevant facts are set out in the Upper Tribunal's decision, paragraphs 10 to 26, and for present purposes they can be stated quite shortly as follows. At all material times, CFE was a taxable person. The carbon credits were acquired by CFE and used by it to make onward taxable supplies. Given the nature and volume of the transactions, it necessarily followed that Stratex, the supplier of the carbon credits, was also a taxable person, and accordingly that VAT was due in respect of the supplies. The total VAT charged in respect of the Stratex transactions amounted to £5.605 million, which CFE duly paid to Stratex, and which the appellant then claimed the input tax deduction in its VAT return for the period 0609. However, the invoices which were issued by Stratex and which appear at pages 1 to 16 of the supplementary bundle were not valid VAT invoices, and they were not valid VAT invoices because they didn't contain a VAT registration number, a VRN, for Stratex, and they didn't include the customer name and address. Now, when CFE spotted those deficiencies, it contacted Stratex and requested corrected invoices. However, despite assurances, no such corrected invoices were ever provided. HMRC then carried out their inquiries into Stratex and discovered that even though it was liable to be registered for VAT, it was not in fact registered for VAT. And it also discovered that Stratex had fraudulently defaulted on its obligation to account for the VAT. Crucially, however, and this is the FTT's finding of fact, the appellant neither knew nor had the means of knowledge of that fraud. So there are two issues in this appeal. The first is whether, notwithstanding the absence of a valid VAT invoice, the appellant is entitled, as a matter of right, to deduct the input tax incurred on Stratex transactions by virtue of having established that the substantive requirements of the right to deduct are satisfied. As to that, the appellant's case is, in short, is that it is so entitled because the revenue knew in advance of issuing their decision to deny the deduction of input tax that the substantive requirements in this case were met. And in the absence of knowledge or means of knowledge of the fraud, we say that the case law is clear, the right to deduct must be allowed. The revenues position, which the FTT and the Upper Tribunal agreed with, is that there is no authority for that proposition, the proposition being that in the absence of a valid VAT invoice, the right to deduct must be allowed if the substantive requirements are shown to be met. Furthermore, they contended that the particular deficiencies in the Stratex invoices, namely the absence of a VRN and the customer name and address, are fundamental requirements of a VAT invoice. And as such, there is no right to deduct in the absence of those items of information. The second issue, which only arises if the appellant fails on its first ground, is whether the revenue are in any event required to exercise their discretion so as to allow the deduction of input tax. And as to that, the appellant's case is simply that having established that the substantive requirements are met, the revenue's discretion may only be exercised one way, namely in favour of the appellant. The revenue's position, again, which the FTT and the Appellate Tribunal...
Just hold on a moment. We only get to issue 2 if you fail on issue 1.
Yes.
And if you fail on issue 1, it's because the VRN is essential.
Yes.
So you say that even though the VRN is essential, HMRC can only exercise its discretion in your favour.
Well, our argument is that if there is no right to deduct, then the second question is there a discretion?
Yeah.
And as to the exercise of discretion, we say that it is formulated in turn, it is a limited discretion to accept other evidence of the charge to VAT. That is the language of Regulation 29.2. And we say that is a limited discretion as to the evidence which the revenue can accept as being satisfactory that the substantive requirements are met. Now, in this case, there's no issue. The revenue are so satisfied. And therefore, where they are satisfied that the substantive requirements are met, they must exercise their discretion in favour of the appellant. Now, the revenue's position, which again the FTT and the Upper Tribunal agreed with, is that the discretion is not simply limited to the question of whether the substantive requirements are met, but it also extends to the question of whether the formal requirements are satisfied. And so the revenue say they were entitled to exercise their discretion on account of the deficiencies in the invoices. So, starting, please, with the substantive requirements of the right to deduct, these are enshrined in Article 168A of the PVD, which is behind tab 3 of the authorities, the first volume of the authorities. And it's page 16. Now, it's common ground that this provision has direct effect, and for your note, the authority for that proposition is BP Supergas at paragraph, which is cited in the Upper Tribunal decision at paragraph 70. So Article 168 provides, insofar as the goods and services are used for the purposes of the tax transactions of a taxable person, the taxable person shall be entitled, in the member state in which he carries out those transactions, to deduct the following from the VAT which he is liable to pay: the VAT due or paid in that member state in respect of supplies to him of goods or services carried out or to be carried out by another taxable person. So the requirements of Article 168 are that the recipient of the supply must be a taxable person, and the goods or services must be used for the purposes of the recipient's own onward taxable transactions and supplied to him by another taxable person. And as I've said, in the present case, it's common ground that those requirements are satisfied, and indeed it was common ground that those requirements were satisfied prior to any decision to deny the deduction. Now, the Court of Justice, we say, has repeatedly stated that the right to deduct is an integral part of the VAT scheme, which may not in principle be limited, including in respect of fraudulent transactions, unless the recipient had knowledge or means of knowledge of the fraud. And if we can briefly turn up Cattell, which is in the second volume, and it is behind tab 18. The relevant passages start at paragraph 45 of the judgment, which is on page 390.
Yeah, I think you can take it that we're all fairly familiar with Cattell principle, which is
Thank you. So
we all have done MTIC cases in the past.
Lucky you. So the absolutely fundamental point which emerges from Cattell is in paragraph 49, where it says the question whether the VAT payable or prior on subsequent sale of the goods concerned has or has not been paid to the Treasury is irrelevant to the right of the taxable person to deduct input tax. So that is fundamental to our case. Returning then to the legislation in volume 1, Article 178 on page 17 provides that in order to exercise the right of deduction, a taxable person must meet the following conditions. A, for the purposes of deduction pursuant to Article 168 in respect of the supply of goods or services, he must hold an invoice drawn up in accordance with Articles 220 to 236. And the relevant provision for our purposes is Article 226, which is over the page at page 19. And this sets out the requirements for a valid VAT invoice and the two...
Sorry, there's another little bit of 178 which we just need to notice, I think, in view of some of the cases. You are an Article 178A case.
Yes.
But a number of the cases are reverse charge cases.
Yes.
Which are Article 178F cases.
Yeah.
Which do not require an Article 226 invoice. Because F only requires compliance with the member states' formalities. There are no formalities in the PVD itself.
Yes, that is correct.
And that point is made in quite a number of the cases.
Yes, I think there are 2 reverse charge cases,
yeah.
But we'll come on to that in a moment.
Because when we get to the cases, there's a whole group of cases which are all about national requirements, which go beyond what the PVD requires.
Correct, yes. So Article 226, the two requirements that are relevant for our purposes are 3, the VAT identification number, and 5, the full name and address of the, and in our case, it's the customer.
Yeah. And 214, which is referred to in 2263, which we haven't got in the bundle, is the obligation of member states to make sure that people get registered.
Yes. So just if we can briefly scroll back up to page 17 and Article 180. So this is the provision which establishes a discretion for member states to permit the deduction of input tax otherwise than in accordance with Article 178. And then you'll also note Article 182 requires member states to lay down the conditions and detailed rules for doing so. And these provisions are then given effect to in our domestic law by sections 24 to 26 of the VAT Act and regulations 13, 14 and 29 of the VAT regs. And these are set out in the Upper Tribunal's decision at paragraphs 39 to 45. Yep. And the only part I wish to highlight to you is regulation 29.2, which is on page 14 of the authorities bundle behind tab 2. And Reg 29.2 provides at the time of claiming deduction of input tax, a person shall, the claims in respect of a supply from another taxable person, hold the document which is required to be provided under Regulation 13. That's a valid VAT invoice. And then at the tail piece over the page, provided But where the commissioners so direct, either generally or in relation to particular cases or classes of cases, a claimant shall hold or provide such other evidence of the charge to VAT as the commissioners may direct. So that's the legislation. Now, in our submission, despite the apparently mandatory terms of Article 178, it is readily apparent from the case law that the need for a valid VAT invoice can be dispensed with in cases where the substantive requirements of the right to deduct are shown to be met. So in effect, whilst compliance with the requirements of Article 178 guarantees the recipient the right to deduct, unless it's shown that the invoice is false, it's not, we say, the only route to deduction, as the case law indicates. So the upper tribunal started its analysis with the jeune homme case, and I'm going to move through the authorities chronologically so that you can see the evolution of the case law. So jeune homme is in the second volume at page 323, it's tab 15. The relevant extract is on page 328. And the issue in this case was whether the Belgian state was permitted to require the provision of certain items of information on a VAT invoice. And in the penultimate paragraph in this page, the AG says an invoice which complies with the rules is the ticket of admission to the right to deduct, subject to it subsequently being shown by the tax authorities to be false. If the invoice does not comply, it may be that the taxpayer can prove the genuineness of the transaction and that his supplier accounted for the VAT which he has paid as input tax. But if the invoice is incomplete in a material respect, the onus is on him to establish his right to deduct. So this, we say, is entirely consistent with the appellant's case. A VAT invoice is the ticket of admission. It guarantees that the recipient can deduct the input tax unless the invoice is shown to be false. But it's not the only means of entry, because in the absence of a valid VAT invoice, it's open to the taxpayer to establish his right to deduct by other means.
Well, not according to the Attorney General, the Advocate General in this case, because you've got to establish that the supplier accounted for the VAT, which you can't in this case. Well, so you have to say the law's changed since this decision.
And we come on to that, but the simple point I make in respect of this is, it's not game over if you don't have a valid VAT invoice. That's not what he says here. It just means that the taxpayer has the burden of proving his right to deduct. Now, we'll come on to what that entails in a moment, but we say that that proposition emerges from the AG's dicta. Now, at paragraph 79 of its decision, the upper tribunal describes the AG here as establishing a clear distinction between the right to deduct and the conditions that must be satisfied before it can be exercised. And in our submission, there is no such distinction between the right to deduct and exercise of the right to deduct. The distinction, as the AG indicates in jeune homme, is between the right to deduct and proof of the right to deduct. So the VAT invoice is the ticket of admission because it is prima facie evidence of the right to deduct. And in the absence of a valid VAT invoice, the taxpayer must prove by other means that it has the right to deduct. And that distinction between the right to deduct and proof of the right to deduct is also highlighted in the next case, which is Reisdorf.
I'm just going back to the Advocate General. Why is he talking about the fact that the supplier accounted for VAT as something which the taxpayer may have to prove on your argument?
Well, we say the taxpayer doesn't have to establish that. And what the court has said consistently is payment of the tax is irrelevant to the right to deduct.
And the genuineness of the transaction, similarly irrelevant or not?
Well, it depends what you mean by the genuineness of the transaction. We would say what he means by that is that you have received you have shown the substantive conditions. In other words, the transaction took place. You were supplied with the goods and services. You are a taxable person. You were supplied by another taxable person, and you used those goods or services to make onward taxable supplies. And if you can show all of those things, the transaction was genuine. But you don't have to show that the tax has been accounted for. And that plainly isn't a component of the right to deduct, because Cattell tells us so. Otherwise, in every missing trader case, the right to deduct would disappear.
I mean, the missing trader cases are often cases where there is no, there is a transaction in carbon credits, but not for the purposes of a genuine business being conducted by the supplier.
Yes. Well, the point in the MTIC cases is that the supplier has disappeared he's pocketed the VAT and disappeared.
Yeah, it's often simply an instrument, a shell company, an instrument of fraud.
Yeah, but the supply took place, and as a result, Cattell confirms the fact that the supplier has disappeared without accounting for the VAT does not impact upon the recipient's right to deduct.
But anyway, you say that the middle part of that sentence, if the invoice doesn't comply, it may be the taxpayer can prove the genuineness of the transaction is just actually wrong?
It may be that there is a distinction to be... If what he is saying by that is that the supplier must have paid the tax, then that is simply wrong. It is contradicted by Cattell and by Bonnick, which both say in terms, and those posts say that. So if the court is taken to have departed from this, then so be it. We accept that. But actually, what he says
the court in Gernon didn't approve that statement. The issue in Gernon was quite a different one, namely whether the Belgian tax authorities could require formalities over and above those required by what was then the Sixth Directive.
Indeed.
And the court said, yes, you can, but they mustn't be too onerous.
Yes. Yeah, no, that's absolutely right. But the word that he uses here is accounted for the VAT. So one might interpret that as him saying, you have to have an invoice that shows VAT as being due and payable, because that is part of your that, if you like, is the initial hurdle to get over to show that you have a right to deduct anything. So by using the word accounted for, we say that can be interpreted consistently with the jurisprudence of the court if what he means is the supplier has to have treated the supply as a taxable supply and charged VAT to its customer. But if what he's saying is the supplier must also have paid it over to the revenue, then that is simply wrong.
Yeah, all right, Reisdorf.
So Reisdorf, we say that we see this distinction again between the right to deduct and proof of the right to deduct.
Well, this is all about whether the original invoice had to be produced or whether a copy would do.
That's
Of course,
exactly
a
what
copy's
is
all right.
concerned, correct.
So what you've got here is one of a number of other codes. First of all, it was a national requirement that was in issue, not anything to do with the Sixth Directive.
Yeah.
And secondly, it's one of another group of cases which we see as we go through, in which an originally defective invoice is later supplemented by other material, which brings the case into conformity with the PVD.
Yes.
So all the details required by the PVD are ultimately supplied by the taxable person, even if they're not initially supplied in the invoice.
That's true, but over and over again, how the court looks at it is to ask itself, have you shown the substantive requirements are met? Nowhere does the court say, have you shown all of the formal requirements of a VAT invoice? Nowhere does it say that. And in fact, if it was going to say that in any case, it was incumbent on it to say it in Verdun, where there were no invoices at all.
Yeah, well, you'll no doubt deal with Geisel, where they say that the VAT identification number is essential.
I will indeed deal with that, yes. So if I can just take you first to the AG in Reisdorf.
Yep.
We can pick it up at paragraph 18, which is page 346, where he says the role of the invoice in the operation of the VAT system is pivotal. It must be issued by each supplier of goods or services to a purchaser who is a taxable person, must be held by the taxable person at the time he claims the right to make a deduction of the VAT shown thereby to have been paid by him to the supplier. And then in 19, the court has left no room for doubt as to the necessity for the taxable person in order to be entitled to deduct the value-added tax payable or paid in respect of the goods delivered or to be delivered or services supplied or to be supplied by another taxable person to hold an invoice drawn up in accordance with the directive. And then he goes on to explain in paragraph 26 that the requirement for a valid VAT invoice is not an immutable rule. So at little e, he says, where a member state's tax authorities are, however, satisfied that despite the inability of the taxable person to produce an invoice, a deductible supply has occurred, then it's perfectly in accordance with the overall scheme of the Sixth Directive. They should nevertheless permit the claimed deduction. And then at little f, he says the plaintiff and Germany are correct to submit that the right to deduct cannot be subject to the ability of the taxable person to present the original invoice in circumstances where he is able to produce other probative evidence in accordance with the rules laid down by the national authorities. And then over the page, in paragraph 27, the bottom of 27, he says, in my opinion, it would be perfectly reasonable for national fiscal authorities to take the view, as the German authorities appear from the order for reference to have done in this case, that a taxable person who simply refuses to produce his invoice or ticket of admission when requested should be deprived of the deduction claimed. On the other hand, the Sixth Directive essentially leaves the administration of the community VAT system to national authorities, and he doesn't think that the directive should be interpreted as obliging those authorities to require the presentation of the original invoices in circumstances where they are satisfied that the original invoice has been lost or destroyed and that the genuineness of the claimed deduction can be shown by other evidence. And we say that that analysis is then echoed in the judgment of the court, which we can pick up on page 352. And the court says at 22, it's apparent from Article 18.1a, which is now Article 178, that exercise of the right to deduct is normally dependent on possession of the original invoice.
Yes, but if you start with 21, they describe mandatory rules for drawing up of invoices. And as we agree, the issue is whether you had to have the original invoice or whether a copy would do. And so in 22, the normal case, the court is saying, is that you need the original invoice. They're not saying you don't need any invoice.
Well, it goes on. It goes on to say
Advocate General, at paragraph 19, to which you took us, had already said that the court left no room to doubt as to the necessity for a taxable person to hold an invoice drawn up in accordance with Article 22.3. So they're not watering that down, except to say, well, if you haven't got the original, a copy will do.
Well, but they're not saying you must always have a copy.
Well, that was the factual situation that they were dealing with.
It was, but again, you know, as we'll come on to see, the court repeatedly stating, notwithstanding a failure to comply with the formal requirements, if the substantive requirements are satisfied, the deduction must be allowed. I mean, that means nothing if you have to have the invoice, the original or a copy. It's positively misleading to say that.
But I mean, equally, every pronouncement by the court has to be read in the context of the particular issue it was dealing with.
It does.
Always dangers in arguments. Well, which take an apparently general statement which has been made in a specific context and then treat it as applying across
Of course,
the board.
but that's always the case
Yes.
with any dicta from the European Court. Of course, it's dealing with the particular circumstances of that case or the particular national provision. But it would have been very easy for the court in for example, Verdun, to say, no invoices, no dice, game over. But it doesn't say that.
And that kind of argument from silence is, I'm not saying it's improper, you can perfectly be entitled to make it, but the force one gives to it may perhaps be lessened by the fact that we do have to read every decision as confined to the, or on the face of it, confined to the particular issue which the court was dealing with.
Yeah, well, you can only go with the dicta that you've got, but nowhere does it say you must have the invoice. How it's formulated its answer is always in terms of, once the substantive requirements are satisfied, the right to deduct must be allowed. And the court repeatedly draws this distinction between the substantive requirements and the formal requirements.
I don't think you get it with respect out of Reisdorf, because if you look at what the court actually ruled on page 354 of the Bible, they say that the sixth directive permit the member states to regard as an invoice not only the original, but also any other document serving as an invoice that fulfills the criteria determined by the member states, blah, blah. So they're not saying, oh, it doesn't matter if you've got an invoice or not. What they're saying is you can treat this as an invoice.
That is the answer in this case.
Yeah.
But at 29, if you look at the bottom of 29, what the court says is, as indicated by the AG in para 26 and 27 of his opinion, that power, i.e. the power to accept other information, includes the power to require production of the original invoice when tax inspections are carried out, and also, where a taxable person no longer holds it, to allow him to produce other cogent evidence that the transaction in respect of which the deduction is claimed actually took place. It's not saying, and also a copy of the invoice. It's going wider than that. Yes, in the circumstances of Reisdorf, they did have a copy of the invoice, but that wasn't the basis on which the court reasoned that Reisdorf's deduction must be allowed in our submission.
Yeah.
If you go back to Genome at page 337 of the bundle, paragraph 14, which is what the Advocate General referred to, are you saying that the court is not there saying that you need to have an invoice? I'm just looking at the first sentence of paragraph 14 of the Genome.
Well, that is what it says. If you isolate that sentence, that is what it's saying. But in Genome, the court limits itself to the specific question before it, namely, can the Belgian authorities require the provision of a certain information on a VAT invoice, and it's heading towards its conclusion in 14 there that it can.
So I thought your submission was that the court has not said that in order to deduct VAT, you need to hold an invoice.
Well, the court has gone on time and time and time again to say, notwithstanding a failure to comply with the formal requirements. So later on in the case law, the court draws a distinction between the substantive requirements of Article 168 and the formal requirements of Article 178 and 226. And it has repeatedly said, notwithstanding a failure to comply with those formal requirements, i.e. to hold a valid VAT invoice, the right to deduct must be allowed where it's shown that the substantive requirements are met. So that simply cannot be right. If it is taken literally, then that statement of the court is wrong.
Well, we'll see as we go through, but essentially your point is that EU law has evolved.
Yes, yes. So the next case is Collet, which is behind tab 17.
This is another case of a national requirement.
This was another case of a national requirement, and it was actually a case about exemption from VAT, not about the right to deduct. But what you will see is that this was the case which established the distinction that I've been referring to between the substantive requirements of the right, in this case the right to exemption, in our case the right to deduct, and the formal requirements. And it's then that dicta then gets picked up in the right to deduct cases. So Collet was a case where the tax authorities had denied, had essentially recharacterised transactions which they considered to be sham transactions. And in response to that, the taxpayer said, well, okay, then you must treat my recharacterised supplies as exempt supplies. And the question was whether the tax authorities were entitled to refuse that treatment on the basis that Collet was not in possession of the right documents and paperwork.
No, that wasn't the ground. The ground was that they were too late in producing it, and that was the way that the German national courts had interpreted German domestic legislation. Look at
The
page
trail was
355
certainly about the
E11.
late production.
Following an investigation, the respondent tax authority refused to allow S to deduct the input tax invoice on the ground that the sale was a sham. Taxpayer amended its accounts to show the sale proceeds as exempt and recorded the transaction thus in its VAT return. Tax authority refused to allow the tax exemption on the basis that the prescribed records had not been updated regularly and immediately after the relevant transaction. And when you get to the facts, you will see that that was the way that the German domestic courts had interpreted their own domestic legislation. And this was, as the Advocate General points out at paragraph 20 of her opinion, this was a case where there were no specific rules as to evidence of an intra-community reply. So this was entirely concerned with German national legislation.
It was, yes. I mean, all these cases are concerned with the national provisions in issue. The point in Collet was that the taxpayer wasn't in possession of the appropriate documentation at the time the transactions took place, and that was, well, that's my understanding of why the German authorities denied the deduction. But if we can pick it up, please, at paragraph 29 on page 371. The court says...
Can we just notice paragraph 24 on page 370? None of the provisions of the Sixth Directive relates to the evidence to be required, so we're not looking at any requirements in EU law.
That are prescribed, yeah. At paragraph 29, the court says, as regards first the question whether the tax authority can refuse to allow an intra-community supply to be exempt from VAT solely on the ground that the accounting evidence of that supply was belatedly produced, should be noted that a national measure which in essence makes the right of exemption in respect of an intra-community supply subject to compliance with formal obligations, without any account being taken of the substantive requirements, and in particular, without any consideration being given as to whether those requirements have been satisfied, goes further than is necessary to ensure the correct levying and collection of tax. And then at 31, the court says, since it's apparent from the order for reference that there is no dispute about the fact that an intra-community supply was made, the principle of fiscal neutrality requires that an exemption from VAT be allowed if the substantive requirements are satisfied, even if the taxable person has failed to comply with some of the formal requirements. The only exception is if non-compliance with such formal requirements would effectively prevent the production of conclusive evidence that the substantive requirements have been satisfied. However, that does not appear to be so in the main case.
Now, the formal requirements, which the court's referring to, are nothing to do with EU law, because we know the Sixth Directive didn't lay down any formal requirements. They are national formal requirements.
But the point in our case is we do have formal requirements which are prescribed by community law, and that is how the court has described the requirements of Articles 178 and 226.
Yeah.
What this case establishes is that distinction.
Well, it doesn't, does it, with respect, because the only formal requirements it's talking about are national requirements.
well, Collet is applied in subsequent cases in the context of the right to deduct as authority for that proposition, but I accept that it's a different context here. And then at 34, the court says whether the fact that the taxable person initially concealed the occurrence of an intra-community supply is relevant to the answer to be given to the referring court, and therefore whether the exemption from VAT may be conditional upon the good faith of that person. The answer to that question depends on whether the member state concerned is at risk of losing any tax revenues. And then at 36 it says it's for the national court to verify, taking into account all the relevant circumstances of the case, whether the delay in the production of the accounting evidence could lead to a loss in tax revenues or jeopardise the levying of VAT. So what the court is saying there is that the risk of tax loss is only relevant if the taxpayer has acted in bad faith. And we say that that is not the case here because the FTT has found that we had neither knowledge nor means of knowledge of the fraud. So the next case is the Eco-Trade case, which is at tab 19. And this concerns the right to deduct in circumstances where the taxpayer was not in possession of a valid VAT invoice because the relevant transactions had initially been treated as exempt when they were in fact taxable and subject to the reverse charge. So if we can...
This is all about Italian limitation periods, isn't it? The taxpayer did have the right documents, but it was too late. And the Italian authorities said, you've lost your right to deduction because 2 years have gone by. On the other hand, we can claim the VAT from you because we've got 4 years.
Yes, I mean, that was the context of it, yes.
But you say the taxpayer didn't have the right documentation, but I think the taxpayer did in the end. Didn't it? .394, in the head note, this is the Italian authorities took the view that the taxpayer had lost its right to deduct because it hadn't exercised the right within a period of 2 years from the time the VAT became chargeable, whereas it was still within the time limits prescribed by Italian law for recovery of the tax. So that's the issue in the case.
Yes, that is the issue in the case. So what the court says at paragraph 63 on page 415 is that since the reverse charge procedure was indisputably applicable to the cases in the main proceedings, the principle of fiscal neutrality requires deduction of input tax to be allowed if the substantive requirements are satisfied, even if the taxable person has failed to comply with some of the formal requirements. And you can see there it applies Collet as authority for that proposition. Therefore, where the tax authority has the information necessary to establish that the taxable person is, as the recipient of the supply of services in question, liable to VAT, it cannot, in relation to the right of that taxable person to deduct that tax, impose additional conditions which may have the effect of rendering that right ineffective for practical purposes. So
we just need to unpack that sentence a little bit, don't we? 63 refers to Collet. As we've seen, Collet involved national requirements going beyond what was required by the 6th Directive. 64 begins therefore. So what it's saying is that Collet, which concerned national requirements, applies to this case, which also concerns national requirements, that is to say, national limitation periods. And then it goes on to say, where the tax authority has the information necessary and so forth, it cannot impose additional conditions. Well, that must mean conditions additional to those in EU law. They are conditions imposed by Italian law, namely you have to exercise your right to deduct within 2 years. That must be what it means, mustn't it?
Well, it's saying, therefore, is in response to what it says in paragraph 63,
Yeah.
which is that the reverse charge procedure was indisputably applicable to the cases in the main proceedings. So,
Right.
and that was so regardless of any documentary failures. That was the case because the substantive requirements were satisfied. And that is what the court is taking Colle to be authority for. It's not saying that that was a finding on the particular circumstances of Colle or in relation to the particular national legislation at issue in that case.
But Ms. Shaw, it's a reverse charge case in which we've seen from
It is,
178F.
I'm going to take you
don't
on
need
to-
to have a 226 invoice.
But I'm just showing you how the case law evolves, where it comes from. It comes from Colle, it comes from eco-trade, and we come all the way through to Verdun and Chemwater at the end. And that's really the point I'm trying to make, is I'm not suggesting that we are a Colle case or an eco-trade case or so, but you see the same mantra being repeated by the court in all sorts of different scenarios.
Chemwater, if I may say so, is by far your best case.
So, so then just quickly to finish off eco-trade, at 70 to 71, the court essentially puts the point that was made by the court in Colle the other way round. And so it says that good faith is only relevant if there is a risk of tax loss. And as I've already mentioned, in this case, the appellant did act in good faith. So the next case is Polski, and that is behind tab 20. And this was a case where the invoices were invalid because instead of naming the partnership as the customer, it in fact named the individual partners who had purchased the assets in question and contributed them to the partnership. So the issue in Polski was that the invoices failed to comply with the requirements of Article 2265, which is one of the deficiencies in this case. So we can pick it up, please, at page 443. In paragraph 40, the court there repeats that the right to deduct is an integral part of the VAT scheme. It then, in 41, refers to the formal requirements of Article 178 and 226, 1 and 5. So it's acknowledging those requirements as formal requirements. And then in paragraph 43, it says the court has held that the principle of VAT neutrality requires that deduction of input tax be allowed if the substantive requirements are satisfied, even if the taxable person has failed to comply with some of the formal requirements. Where the tax authority has the information necessary to establish that the taxable person is, as the recipient of the supplies in question, liable to VAT, it cannot impose, in relation to the taxable person's right to deduct that tax, additional conditions which may have the effect of rendering that right ineffective. So that, we say, is the now familiar mantra that the right to deduct must be allowed if the substantive requirements are met, even if the taxpayer has failed to comply with some of the formal requirements, including in relation to the requirement to state the customer's name and address, as is the position here.
Is that right? If you go back to 42, don't you have to read these paragraphs as a whole?
Yeah, so 42, the court is saying that it's not open to member states to make the exercise dependent on compliance with conditions other than those
Additional
laid
obligations
down.
over and above those laid down by the
Yes.
But it's not.
But then it's
not
saying, in
you
addition-
comply with the directive.
No, but it's saying in 43, in addition, the court has held. So it's saying two things. It's saying it's not for the member states to impose additional requirements to a valid VAT invoice that are not specified in Article 226. And it's saying, in addition, fiscal neutrality requires that where the substantive conditions are shown to be met, the right to deduct must be allowed, even if there is a failure to comply with some of those formal requirements set out in Article 226.
But it's not necessarily saying that all formal requirements have to be treated alike for these purposes, is it? I mean, it says some of them, which leaves open the question whether there may be formal requirements which are nevertheless ones which are
it does say
essential.
It does say some, but the court has never said that some of these requirements are indispensable, and I will come on to the
well, that's what we're coming on to.
In Giesel, where it says an essential. Yes.
Can we just notice what the Advocate General had to say in analysing the case law? Page 434 and following. He says that the court's case law, paragraph 68, the court's case law has interpreted provisions fairly loosely, and he sets out what the objective is. And then he says at 69, it's this approach that's led the court to limit the member states' discretion to restrict their ability to require invoices should contain information beyond that contained in the directive. Similarly, the Court of Justice has taken the view where invoices contain errors or defects which are capable of correction, the taxable person must be allowed to make the correction before being denied the right. So he certainly doesn't say that if you can't correct an invoice, never mind, you can deduct anyway. What he is saying is you can't impose additional requirements to those in EU law, and if an invoice is defective, you must allow it to be corrected before you deny the right.
Yes, and that is undoubtedly the position, but the court does not say you must correct the invoices in order for your right to deduct to be allowed.
All right.
Now, in 101 of the Upper Tribunal's decision, they describe Polski as a case in which the information required by Article 178 was provided by other means. But in our submission, that is not what the court said. So in paragraph 44, which is back on the court says that it's apparent that the requirements of Article 168 are satisfied. So it doesn't indicate here that it's anything to do with satisfaction of the formal requirements of Article 178 and 226. And in paragraph 46, the court says that having established that the substantive requirements were met, compliance with the requirements of Article 178 could not be required. So we say that nowhere in this case does it indicate that the taxpayer is required to establish the formal requirements of the right to deduct. In fact, quite the reverse. So the next case is Bonnick, which is at tab 21. And in this case, the invoices failed to identify the true supplier of the goods.
Sorry, where are we? Bonnick?
We're Bonnick, yes, next tab. And we can pick it up at paragraph 25 of the judgment, which is on page 453. And we see here again the court repeating the proposition that the right to deduct is a fundamental principle of the VAT scheme. Then at 28, it repeats the point made in Patel that payment of the tax by the supplier is irrelevant to the right to deduct. Then in 29, the court sets out the requirements of the right to deduct in Article 168. First, that the interested party be a taxable person within the meaning of that directive. Second, that the goods or services relied on to give entitlement to that right be used by the taxable person for the purposes of his own taxed output transactions, and that as inputs, those goods or services must be supplied by another taxable person. And then in 30, the court observes that Bonnick and its supplier are taxable persons, and then says the remaining question is whether the supplies have actually been made and whether the goods were used by Bonnick for the purposes of its taxable activities, which is a matter for the National Court.
But this case was nothing to do with a deficient invoice, was it? This case was all to do with an underlying fraud. Whether the member state could say if it was an underlying fraud, you can't deduct.
That's true. That was the factual circumstance in Bonnick, yeah. But the court is here talking about the requirements of Article 168, the right to deduct.
It's not a case in which the issue of a defective invoice was in their consideration at all.
Well,
so they're just not addressing the relevance of not having an invoice or not having a valid invoice.
Well, the only reason that they had an issue was that they didn't have a valid VAT. If they had the valid VAT invoice, they'd be making the deduction anyway. So the reason why the difficulty arose in Bonnick was because it didn't have a valid.
Why had they not had a valid invoice?
So in Bonnick, the supplier wasn't the true supplier of the goods.
So I'm looking at paragraph 11. Bulgarian tax authorities found there was no evidence of the intra-community supplies of wheat and sunflower declared by Bonnick as having been carried out. According to Bonnick's account, the quantities of wheat and sunflower quoted on the invoices issued by Bonnick had been taken out of its stock and weren't there. Bonnick had in its possession, this is 13, invoices relating to those purchases issued by Favorit and Agro. And then the Bulgarian authorities check, and they couldn't find that those transactions had taken place. But as my lord says, they appear to have had what were apparently perfectly valid invoices. Did they not?
Point in Bonnick, this may be another case, is that Bonnick had made the supply, so it was not in dispute that Bonnick had onward supplied the goods in issue. The question was who had it purchased those goods.
The Bulgarian authorities thought they'd taken it out of its own stock, not hadn't acquired it from the people who they said they'd acquired it from, although they had invoices.
The whole case just turns on the question of the underlying substantive nature of the transactions, not on the question of any absence of invoices or deficient invoices. I mean, if you look at the reference, paragraph 23, the questions that are actually referred, nowhere is there any issue about somebody not having an invoice or a defective invoice, or indeed anything, because the whole, as I understand it, the whole fact pattern of the case was that there were invoices covering these supplies. The question was, where did the wheat come from?
Yeah, but the point in Bonnick is that again, what you see the court doing is repeating this proposition as to if you can establish that the substantive requirements are met,
Yeah, but in the
then
case,
the right to deduct must be allowed.
But they're not addressing the issue which is actually relevant, which is that the case where you don't have a valid invoice or an appropriate invoice complying with the directive? Because that wasn't the question in the case.
No, I accept that. But what the court says over and over and over again is, if you can establish that the substantive requirements are met, then the right to deduct must be allowed. And it goes on to say at 40, the right cannot be refused unless it's established that the taxpayer knew or should have known that he was participating in a fraud. And then it says at 41, it's incompatible with the rules governing the right of deduction to impose a penalty in the form of refusal of that right.
But you're trying to rely on that as in support of your argument that it doesn't matter. The invoices just don't matter, to put it bluntly. And all I'm pointing out is that I don't think that in this case they were turning their mind to the importance of the invoices.
No.
Because the taxpayer had, at least on the face of it, what appeared to be valid invoices.
No, I think that is a valid comment. But the point that they are making is what is the taxpayer required to do in order to establish their right to deduct, and that is what the court is talking about here.
Yeah, but I don't think you can. I'm struggling at the moment to draw from this case. Also, the court saying, and it doesn't actually matter a jot whether you have an invoice, what it says at all.
No, well, it doesn't say that in this case. Yeah. Yes. So the point that the court is making here is that even in the context of fraud, that doesn't impact upon the recipient's right to deduct unless the recipient knew or had means of knowledge of the fraud. At 28, again, it makes the point that whether or not the VAT has been paid by the supplier, again, does not affect, is irrelevant to the right to deduct. So that's really what Bonnick is authority for. The next case is Petroma, which is behind tab 22. And this was that the deficiency in the invoices in this case were to do with the insufficient particularity of the quantity of the services. Yeah. This was a case where the Belgian authorities decided to refuse deduction, and after that decision had been adopted, the taxpayer then sought to correct its invoices. So we can pick it up on page 464. Where the court says it must be stated that the information necessary to complete and regularise the invoices was submitted after the tax authority.
Can we go back, please, to 25, page 463. With regard to the rules governing the exercise of the right to deduct, 6 directive provides a taxable person must hold an invoice drawn up in accordance with Article 22.3. 27. It follows that with regard to the exercise of the right to deduct, the 6th directive does no more than require an invoice containing certain information. Member States may provide for the inclusion of additional information to ensure the correct levying of VAT and to permit supervision. So they're not saying, as my lord put it, the invoice doesn't matter a job. They're saying you've got to have an invoice. That's what the 6th directive tells you.
Well, yes, okay, but we'll come on to all of the other cases. Then say, in the absence of the formal requirements, if the substantive requirements are met, the right to deduct must be allowed.
Well, that depends what you mean by formal requirements, because as I suggested to you, many of the cases concern national requirements rather than EU requirements.
I mean, 28 as well.
The court has repeatedly stated that the requirements of 178 and 226 are formal requirements.
But they are requirements.
But they are formal, and the distinction is meaningless. Otherwise, just say these are the requirements.
Well, I mean, 28, the requirement that the invoice should contain particulars other than those set out in Article 22.3b as a condition for the exercise of the right to deduct must be limited, etc., etc. It's implicit in that what is set out in 22.3b of the 6th Directive is a condition of the exercise of the right to deduct, isn't it?
Well, as I say, that's not how the court has put it. It said those are the requirements. If those are the requirements, and they are,
You haven't yet shown us a case which backs your proposition, because all these cases are dealing with other questions. So we need to get on to the cases which you say do back your proposition.
well, so if I can ask you just please to look at 35 and 36 on page 464. The point in Petroma, what did for the taxpayer in Petroma was that it sought to correct its invoices after the decision to deduct had been taken. And in this case, the taxpayer had established that the substantive requirements were met in advance of the revenue's decision to deduct.
But if that's a satisfactory explanation of what this case is saying, then doesn't that in itself, on your argument, suggest the court got it wrong? Because if it's just a matter of being too late, I mean, that's just the kind of thing you can. Why can't you correct it later? Thus, many of the cases are about providing the necessary information later than was necessary at first blush. And the point then is, it's okay as long as you satisfy these substantive requirements. But here, you end up with the taxpayer being deprived of a deduction, even though it did eventually provide all the necessary information.
Yeah, but Petroma is a bit of an outlier in that regard. It is an exception to the rule that it's not in every case that if the substantive requirements are shown to be met, then the right to deduct must be allowed if the fault, notwithstanding.
Well, that's really the burden of your case, isn't it?
Well, there are some exceptions. So, for example, if it's shown that you knew or had means of knowing of the fraud, then you're not entitled to deduct. In Petroma, if you adduce your evidence, in Petroma they happen to provide corrected invoices, but if you adduce your evidence after the decision has been taken, then you may be denied the right to deduct.
I'm struggling actually with your 35 and 36. It seems to me that they say, actually, don't they say the opposite of what you're saying? I mean, what it's saying is that a national legislature can enact legislation under which the right to deduct VAT may be refused to people who, albeit that they are recipient of services and are in possession which of invoices are incomplete, can't claim the tax, even if after the event they produce, as it were, they correct the invoices. They're accepting that you can be denied tax under national legislation if you don't get your invoices right. At the
Yes,
time of decision.
after such a refusal decision was adopted. So we do accept that that is an exception to the principle that if you can establish the substantive.
But if the invoices
requirements
don't
on
matter, why are they reaching that? Why are they accepting that that's legit? I mean, you'd say member states can't deny people on the basis that they haven't got their invoices in order, because you'd say the overriding requirement is simply to have the recipient, that you are a taxable person and you receive the requirements from another taxable person. You've entered into a transaction with another taxable person, you've received the goods and services for the purposes of your own business. That's an end of the matter, and anything to do with these bits of paper is just irrelevant. Yeah, I mean, that's your proposition, isn't it? It's as high as that.
No, it's not as high as that. I accept that Petroma is an exception to my proposition, and there are other exceptions. So if the taxpayer knew or had means of knowing of the fraud, it doesn't get its deduction. That is an exception to my proposition.
But that depends on the EU principle of abuse of rights. I mean, that's nothing to do with VAT, in a sense.
Well, it's It
Well,
is
it's
to
applied
do,
in VAT, but it applies also right across the board.
it is, but Cattell, it concerns the right to deduct
Yeah.
and whether it is impacted by that, and it says it is impacted by the existence
Yeah,
of
but
fraud.
we're concerned with PVD and what it means.
Yes.
I mean, at 31, for instance, in Petroma, the court says it's not open to member states to exercise the right to deduct on compliance with conditions which are not expressly laid down by the provisions of the PVD. So, implicitly, you can make exercise of the right to deduct conditional on compliance with conditions which are laid down in the PVD. And that's supported by what the court actually decides.
Well, you've got my point on
All right. Well, that's Petroma. Yeah. Arliss next.
Yeah. So the point in Petroma was that they didn't have evidence of the substantive requirements at the time, at the relevant time. So they didn't have information around the occurrence, nature, and amount of the transactions involved. So next case is Barlis, which is behind tab 23. And again, the invoices in this case fail to particularise the nature of the services or specify the dates of the supplies. Starting with the AG on page 472.
Shall we just notice her paragraph 2? EU law provides that invoice must contain certain minimum information.
Yeah, so that's an acknowledgement of the requirements of 178.
Yeah. Paragraph 20 must be clarified whether the invoices meet the requirements of Article 226 as regards the contents of the invoice. On your argument, it's not necessary that they do, so it's an irrelevant question. 22, the mandatory contents of the invoice are laid down in a binding and exhaustive manner by Article 226.
So in paragraph 30, she explains that the purpose of each of the formal requirements turns on the function of the invoice in assisting the tax authority with their monitoring activities. And then at 32, she says an invoice is intended first to enable a check on whether the person issuing the invoice has paid the tax. And then at 33, she explains...
This is all to do with a requirement imposed by the domestic legislation which went beyond Article 226.
Well, the 226 requires you to specify the services.
Yeah.
The question was whether the particular articulation of that went beyond what was required by 226. Then at 33, she explains that in order to exercise the right to deduct, the recipient must hold an invoice, and that requirement is intended to ensure that VAT is levied and supervised. And then in the last sentence, she says, the VAT shown in an invoice is payable by the person who issued it, regardless of whether a liability to tax has actually arisen, and in particular, whether any supply has actually been made. In such cases, this saves the tax authority from requiring other evidence. And then she says, so the invoice is a type of insurance for the fiscal authority, in that in a certain sense, it links the input tax deduction to payment of the tax. The invoice without which no input tax deduction may be made, gives the fiscal authority at least the possibility of recovering from the person who issued the invoice the amount of money that goes out by way of input tax deduction, in that the tax authority is able to monitor payment of the corresponding tax by him.
Right, but this is all to do, unless I've misunderstood this is all to do with, do the requirements imposed by the the Portuguese government, go beyond what Article 226 actually requires? in terms of the specificity of the services or goods, and that the Portuguese government is trying to justify the specificity of the requirement that they have imposed because it serves these policy considerations. And the question is, are they right in that? But nobody, the big elephant in this room, if you're right, is that somebody should have said, why are you fussing about what the invoice is? You don't need them. Who cares?
Well,
I mean,
I
is
don't
it
think
really as blunt as that?
I don't think that is how either the directive or the court has approached it. What they are saying, it's the point made by the AG in Gernom
isn't that actually how you are asking us to approach it?
In Gernom, what we say the AG is explaining is this is your guarantee. If you've got the reason why the invoice matters is that you are absolutely guaranteed to be able to deduct your input tax. And actually, what the AG is explaining in Barlis is why that is the case. And the invoice is an insurance for the revenue that they can collect the output tax, which is then deducted by the recipient. So there's a symmetry there. If you show the VAT on the invoice, then the revenue can collect that amount. And that's your absolute guaranteed means of entry. But as I say, it's not the only way of establishing your right to deduct.
So the AG is wrong at 34 when she says the invoice without which no input deduction may be made. That's completely wrong.
Well, in 34, I think what she's explaining is what the invoice is insuring against. And what the invoice is insuring against is the possibility that a claim for input tax might be made when the revenue have no ability to collect by way of output tax that amount from the supplier. She's explaining, this is under the heading monitoring payment of the correct tax. So she's explaining what function the invoice serves in that.
Well, undoubtedly, that's a very important function of the invoice, and it gives the revenue authorities an opportunity to actually claim the tax without more once it's been charged as such in an invoice.
Yes.
The question is that an exhaustive statement of why an invoice is essential? And on the face of it, the Advocate General here is saying it is essential because without it, no input tax deduction may be made. And she goes out of her way to say that, even though she's just been describing the type of insurance which you're putting to us. Doesn't that rather suggest that that's just one of the reasons, albeit an important one, why the invoice is essential? I mean, other reasons, obviously, could be because of the help it provides the invoice, the help it provides for the revenue authorities just to check the bona fides of the transaction, whether there's fraud involved, whether indeed there was a real supply of goods, or whether, as in the present case, it was all a fly-by-night operation, which amazingly was never spotted by your clients.
Yeah, so she goes on to explain at 35 that the insurance function only requires certain of the details to be to be included in the invoice. It's the complete name and address of the taxable person, supplemented by the VRN. So what the insurance function of the invoice requires is that the tax authorities can identify the supplier so that they know whom to collect the tax from. And the VRN is supplementary to those requirements. And in our submission, if, as in this case, the tax authorities are able to identify the supplier from the other information that they have, most notably the name and address of the supplier, then the VRN is, we would say, plainly not a fundamental requirement. In the absence of the VRN in this case, there was nothing to stop the revenue, and indeed they did monitor the transactions.
Are we going to come on to this argument about what supplemented actually means at some later stage? Or?
Well, supplementary means in addition, but it doesn't mean fundamental.
But if you substituted the words together with, it's the complete name and address together with the VAT number.
Yeah, but what she's explaining is that The reason why you need this information is so that you can identify the
No,
supplier.
so I just want to know whether I'm about to have an argument or discussion with you at the right stage of the argument. There is a point about what supplemented means in this case. You know, what is meant by that word supplemented, as I understand it. If we're going to have that discussion later as to whether this is establishing a hierarchy of information, the importance of the VRN, let's leave it till later.
No, well, we can have the discussion now, but there's not a hierarchy in our submission. What the AG is explaining is that there are certain requirements of the VAT invoice, the name, address, and the VRN of the supplier, and the function of those items of information is to identify the supplier. Now, if you can do that, if you have two of those three items of information, you do not need the third item of information in order to identify the supplier, and therefore it is not a fundamental requirement if that is your view of the function of those provisions.
Right. So we're holding you up, Ms. Shaw. I just noticed the time, so you need to move swiftly on.
So then at 46, she says that the invoice also has the function of proving the recipient's right to deduct. And then at 97 and 98, she says, in a case in which there is no longer any doubt that the substantive requirements for the right to deduction are met, the monitoring function of an invoice is obviously OTOs to the extent that it is intended to support monitoring of the entitlement of the right to deduct.
Do we need to notice paragraph 80? As regards formal obligations which concern invoices, there's specific legal provision. In its consistent case law, the court is therefore held the exercise of the right to deduction depends on the invoice containing the details required by Article 56. That's wrong, you say.
Well, that's not something that is, this part of her opinion is not something that's picked up by the court.
No, just a simple question. You say it's wrong.
We do say it's wrong. We say that the invoice is not mandatory. And then at 97, so what she says at 96 we say is correct. If you can, once you've established the substantive requirements, then the
Without
monitoring...
wishing to delay you, and just paragraph 80, to which my lord referred you, why she highlighted the word additional, penultimate line. She's gone out of her way to be wrong, in fact. She's saying you do have to have an invoice, you just mustn't make it exercising it subject to additional requirements as regards the contents of an invoice which are not provided for in the directive.
Yeah, well, our submission is that's wrong. So then at 97, she says, as already seen, the invoice also serves for monitoring of the payment of the correct tax by the person who issued it. To that extent, the invoice, and in particular its correction, still perform a monitoring function. First, a request by the recipient of the invoice that the invoice be corrected requires the person who issued it himself to check whether he has correctly accounted for tax on the supply, which is the subject of the invoice. Secondly, correcting the invoice also provides the tax authorities having jurisdiction over the person who issued it with a sounder basis for monitoring whether the person who issued the invoice correctly paid tax on it. And we say that that is not a proposition endorsed by the court. And so at paragraph 27, on page 489, the aspects of the AGO that are endorsed are 30, 32 and 46. And those are the paragraphs in which she explains the function of the invoice. Then at 38 and 39, the court repeats that the right to deduct is an integral part of the VAT scheme, intended to ensure neutrality. At 40 and 41, the court again distinguishes the requirements of the right to deduct set out in Article 168 from the formal requirements of Articles 178 and 226. And then at 42, it repeats that the right to deduct must be permitted if the substantive requirements are satisfied, even if the taxable person has failed to comply with some of the formal requirements. Then at 43, it says it follows that the tax authorities cannot refuse the right to deduct on the sole ground that an invoice does not satisfy the conditions required by sub 6 and 7 of 226, if they have available all the information to ascertain whether the substantive conditions for that right are satisfied. In this respect, the authorities cannot restrict themselves to examining the invoice itself. They must also take account of additional information provided by the taxable person. So the taxpayer, the tax authorities cannot refuse the right to deduct if they have all the information necessary to establish that the substantive requirements are met, notwithstanding any failure to comply with some of the formal requirements. And in that regard, they cannot restrict their inquiry to the invoice itself. They must take account of any additional information adduced by the taxpayer. And then at 49, the court says, Article 178 must be interpreted as precluding the national tax authorities from refusing the right to deduct VAT solely because the taxable person holds an invoice which does not satisfy the conditions required by sub 6 and 7, even though the authority have all the information necessary for ascertaining that the substantive conditions are satisfied. Next is Senatex, and I'll just give you the paragraph numbers of this. It's 26 and 27, where you see, again, familiar statements as to the fundamentality and function of the right to deduct. 28 and 29, you see the distinction between the substantive requirements of 168 and the formal requirements of 178 and 226. 38, where you see the mantra that deduction of input tax must be allowed if the substantive requirements are met, notwithstanding any failure to comply with some of the formal requirements.
This was another correction of an invoice case, wasn't it?
Subsequently, yes. But the point that the
Senatex
court,
didn't have the VRN of its supplier, but ultimately supplied it.
true, and that is described as a formal requirement in Senatex. And the point in Senatex was that Senatex was entitled to deduct in the period in which the transactions took place, and it wasn't open to the tax authorities to deny deduction to a subsequent point, i.e. the point at which the invoices were corrected.
So this is the first, these paragraphs 40 through to 43, 43 I think, and the holding in Barlis are probably I think these are the strongest so far from your perspective, aren't they? Statements effectively saying, even if you don't have the formal requirement, or some of the formal conditions satisfied, in other words, in relation to an invoice, but the authorities have the relevant information by another route, then they should allow the tax to be claimed.
Yes.
But if we look at Senatex, paragraph 33 on page 510, it's common ground the invoices were properly corrected. And then at 35, the court says deductions to be made by subtracting from the total amount of VAT, etc., etc. It follows, they say, between E and F, that the right to deduct VAT must in principle be exercised in respect of the period during which first the right has arisen, and secondly, the taxable person is in possession of an invoice. So they're not saying it doesn't matter whether you have an invoice or not.
But the point
They're
is
still saying that the right to deduct is dependent on the invoice.
Well, but it clearly can't be in Senatex, because at the point at which the right to deduct arose in this case, Senatex wasn't in possession of a valid VAT invoice. It had an invoice that was deficient. It didn't have the VRN in it.
Yeah.
Yeah, and then if you look at the bottom of paragraph 38, it says in terms, holding an invoice showing the details mentioned in Article 226 is a formal condition, not a substantive condition of the right to deduct. So next we have Giesel, and the issue in this case was whether the invoice needed to state the supplier's place of business as opposed to its registered office. And we can pick it up in the AGO at 40 on page 519. And he says in the second sentence, the indication of the address of the issuer of the invoice serves in combination with his name and VAT identification number the purpose of establishing a link between a given economic transaction and a specific economic operator, the issuer of the invoice. In other words, it allows the issuer of the invoice to be identified. That identification is essential for the tax authorities to be able to perform the necessary checks as to whether the amount of VAT is declared and paid. In turn, the identification also allows the taxable person to verify whether the issuer is a taxable person for the purposes of the VAT rules. So we say that, properly understood, the AG in Giesel is making the same point as the AG in Barlis, which is that the VRN is a complementary requirement, not a fundamental requirement, and its function is to enable the tax authorities to identify the supplier. And if the supplier can be identified from the other information available to the tax authorities, then in our submission it's plainly not a fundamental requirement. And then at 42 it says, he says, I cannot share the view expressed by the Austrian and German governments that the existence of actual economic activities or tangible presence of the trader's business is necessary to enable a correct identification of the issuer of the invoice and to contact him. In accordance with 226, the invoice also needs to include a number of other elements which serve that purpose. Among those, the VAT identification number is of particular importance. That number can be easily verified by the authorities. In addition, the validity of that number can also be verified, including online, by anybody.
But so I don't understand why this case is going to the court on the basis that there's no doubt that the material conditions for the deduction of input tax are not at issue in these proceedings. I'm just reading the start of paragraph 27. I mean, if that's right, and you say that's all that's necessary, why are they going on about this? I mean, in other words, you just say, look, there's no issue. The material conditions for deduction of input tax are satisfied, as indeed you say in our current case. So what's the rest of this all about?
Well, I think the AG is trying to explain why it's unnecessary to identify the supplier's place of business and why the registered office is not sufficient. And it's explaining that the function of that requirement is simply to enable the supplier to be identified. That's what the AG is doing here.
But if, sorry, maybe I'm just being too simple about this, but the issue is, can the taxpayer deduct? If the answer is yes, because it's common ground, the material conditions for deduction are satisfied, which I think is what's being said here, isn't it?
Well, the issue was whether the German requirements, which required the place of business, rather than simply the invoice had the registered office of the supplier on it, and the German authorities said, no, you need the place of business where the economic activities are being carried on. And so that's the issue that's being addressed. And here the AG is explaining why you don't need the place of business. What you need to be able to do is identify the supplier.
Well, he's not quite doing that, is he? The PVD required the invoice to include the address. That's the obligation. That's what he says at paragraph 4.
Yeah.
So what the court is doing, what he and the court are doing, are interpreting what the word address means in the PVD. German tax authorities say a letterbox isn't good enough. You've got to have the place where the supplier actually carries on business. And the court says, no, you don't. Address means address. It's just a letterbox address is absolutely fine.
Yes.
What they don't say is, well, you needn't say anything at all about the address.
No, but that wasn't the question referred
No,
to.
it wasn't. As my lord says, well, what was the point of the question if your argument is correct?
Why doesn't you just say, go away, stop bothering us with this? We've told you, you only need to satisfy the material preconditions. We've got other cases to do.
Well, they're answering the question posed, and they're explaining that this is the function of the
But they don't
address.
have to answer the question posed if they think it's a stupid question.
Well, they're explaining. I mean, it is a formal requirement of Article 226 that the address be stated, and they are answering what the function of that requirement is. They're not saying that in the absence of it, you don't get your deduction. So at 42 and 43, 40, 41, 42, 43, we say that we make the same point as in respect of the AG and bar list, that the VRN is a complementary requirement, and if you can identify the supplier from the other information, then it's not a fundamental requirement. And what the AG emphasises in 42 and 43 is that the importance of the VRN is in the revenue carrying out their audit function. And so in order to audit the transactions, the revenue need to know who the supplier is. And what we say is that there is a distinction between the revenue's audit function on the one hand, and that is essentially what the formal requirements go to, and the recipient's right to deduct, which is what the substantive requirements go to. And so we say that importantly, what the AG is not suggesting in Giesel is that the VRN is of particular importance to the right to deduct, saying it's of importance to the audit function. And then at 62 to 65, he addresses there the question of good faith and due diligence, and I'll leave you to read those paragraphs, but what he says is that in the absence of knowledge or means of knowledge, it's not open to the revenue to subject the appellant to a more complex duty of care or a heightened due diligence, because that would, in effect, reverse the burden of proof and put it on to the taxpayer to show that they had done everything necessary to satisfy themselves. And then moving on to the judgment at page 533.
Well, just before you go to 533, what about paragraph 30 at page 532?
Yeah, well, he's repeating the point that we've seen in the other cases, and as I say, the way that should be interpreted is that it's mandatory in the sense that it is the guaranteed way of exercising your right to deduct, but it's not the only way of establishing your right to deduct. If you can demonstrate that the substantive requirements are met, then in the absence of compliance with those requirements, the right to deduct must be allowed. So he cannot literally mean that that is the only way of exercising your right to deduct, because that's not how the court has approached it. Yes, and if you read on to 40, he says that holding the invoice is a formal requirement. Deduction must be allowed if the substantive requirements are satisfied.
Well, again, they say even if the persons have failed to comply with certain formal conditions.
Yeah.
Does that mean even failed to comply with those formal conditions which are set out in Article 226, or are they talking about
Well, they're just speaking.
other formal conditions?
Again, in our submission, they're speaking to the circumstances of that particular case. There were certain requirements that weren't satisfied, and what the court is saying is it doesn't matter. It's true that the court hasn't anywhere said.
But the context of 40 is actually 38, isn't it? It's not open to member states to make the exercise of the right to deduct dependent upon compliance with conditions relating to the content of invoices which are not expressly laid down in the VAT directive. And so when they talk about failure to comply with certain formal conditions, I mean, are they not talking about those which don't appear in the VAT directive?
No, so it says in 39 in the second place, with regard to the context of which Article 226 of the directive forms part, should be recalled that the right to deduct may not in principle be limited.
Yeah, but they could say
In that regard.
Adding the words may not in principle be limited by adding conditions which are not expressly set out in Article 226.
Well, it's referring there to Senatex.
Yeah.
And then says the court has held in that regard, holding an invoice is a formal condition. I think I was taking you to 62 to 65, where again he addresses the question of no, that's in the judgment, I'm sorry. So yeah, page 533 in the judgment. The court there addresses the question of well, let's pick it up at 43. So the court says it should be noted that the VRN of the supplier of the goods is an essential piece of information in that identification. That number is easily accessible and verifiable by the tax authorities. So when it's talking about that identification, it's talking about identification of the supplier. And in our submission, when the court says essential piece of information, what it means is important piece of information, not that it's a requirement that cannot be dispensed with. And that's because, as it explains in 45, the aim is to identify the supplier.
Yes.
And then at
I mean, just to be clear, when we are looking back to Senatex, or when they refer back to Senatex and talking about failing to comply with certain formal conditions, and you track back to Senatex, Senatex tracks back to Polski, and Polski, paragraph 41, is actually dealing with a question about whether member states can make the right to deduct VAT dependence and compliance with conditions which are not expressly laid down in the directive. You actually track. I think if you actually track back. Sorry, it's taken me a few moments to get to track back. But when I asked you about paragraphs 38 to 40 of GISO, their reference back to Senatex are to paragraphs which refer back to Polski, and the relevant paragraphs of Polski are talking about additional requirements over and above that which the directive requires. Isn't that right?
So
So if you go back to Senatex, to paragraph 37 to 38, that refers you back to paragraph 29 of Senatex. So paragraph 38 of Senatex refers you back to 29 of Senatex. 29 of Senatex refers you back to Polsky and to paragraph 41 of Polsky. When you go back to paragraph 41 of Polsky, it's talking about imposition of formal requirements over and above the requirements of that which is in the directive. I think. I'll leave somebody else to track it down. But that's how at the moment I read that.
Well, I think you can say that Senatex paragraph 38 does say that holding an invoice showing the details mentioned in Article 226 is a formal condition. You're entitled to say that.
yeah,
I mean, my point is that if you go back to 29, you go,
Yeah.
in fact, are asking you to go back to Polsky. When you go back to Polsky, paragraph 41, in fact, it's paragraph 41 and 42. Sorry, well, 40 to 42, you've got to read it in context. And it says, as regards formal requirements, it's apparent that its exercise is subject to holding an invoice. And, then 42, it follows it's not open to member states to make the exercise of the right to deduct dependent on compliance with conditions relating to the content of invoices which are not expressly laid down by the directive. Talks about additional.
yeah. So, well,
Anyway,
the point that's being made in Polsky is in a narrower setting, and then the point that's being made in Senatex is in a wider setting. So it's applying that more generally.
so you say what the law has, these cases have morphed, so that in fact they should be read as saying, actually, it just doesn't matter what the invoice says if the substantive requirements are complied with, and
Yeah.
you just don't need an invoice.
Yes.
Full stop.
Yeah. And so, the key point from Giesel is that nowhere in the judgment does the court indicate that the VRN forms part of the substantive requirements.
Well, by yeah.
Yes, the point that the court is making in Senatex with regard to Polsky is the distinction between the substantive and the formal. It's saying the requirements to hold a valid invoice are formal requirements, and that is something which is then maintained in the subsequent case law. So the next case is Verdun, which is at tab 26. And this, as I said, is the case where there were no invoices at all. So it's not just a question of certain deficiencies. None of the formal requirements were met. And we say that if it was the case that certain of the formal requirements were absolutely fundamental, or that it was necessary to correct the invoices or satisfy certain of the formal requirements, then this would be the place for the court to say that. But that's not what the court says. And if we can pick it up at page 5.
So just to be clear, the Advocate General got it wrong from the off. First sentence, first paragraph, wrong.
What does he say?
Just to be clear, the invoice is an essential element of a taxable person's right to deduct input VAT under council directive.
Yeah, he's
So
saying...
wrong, right from the start.
Well, it depends what you mean by essential. It doesn't mean...
Without which you can't get it.
Without, right, well, if that's what he means by it, then that is wrong.
What
If
does
what
that
he means is it's an important, it's important because it is the ticket of admission, then
Well, just
fine.
so in fact, you'd say, he should have said, instead of saying it's an essential element, he should have said the invoice is not a necessary element.
Well, he's starting off by explaining,
By getting it wrong.
well, by explaining that it is the usual way in which you claim your right to deduct. We don't deny that. The question is it the only? Is it the only way? So if by essential he means it's the only way, then that is wrong.
Yeah.
If he means it's important, then we take no issue with that.
All right. Can we just look at the question? Paragraph 555, page 555 rather, paragraph 33. On a proper construction of the VAT directive and the principles of proportionality, may a taxable person who satisfies the substantive requirements for deduction of VAT exercise his right to deduct in a situation where in a particular context, such as that of dispute in the main proceedings, he is unable to provide evidence by way of invoices for input tax for the supply of goods and the provision of services. You would say, or the court should have said, yes, of course he can, but they didn't.
Well, they don't say no either. I mean, they don't say, in the absence of the invoices, forget it. What they go on to explain is that if you establish the substantive requirements, then you get your right to deduct, but you can't, if you like, assume it. You can't produce an expert report which estimates the input tax that you might have incurred. You've got to show that you did incur it. So that's what Verdun says. But if the answer to that question was, in the absence of valid VAT invoices, you can't have your deduction, then the court would have said that. But it doesn't. It says at 43, it's for the taxable person seeking deduction of VAT to establish that he meets the conditions for eligibility. The taxable person is required to provide objective evidence that goods and services were actually provided as inputs by taxable persons for the purposes of his own transaction subject to VAT, in respect of which he's actually paid VAT. That evidence may include, inter alia, documents held by the suppliers or service providers from whom the taxable person has acquired the goods or services in respect of which he's paid VAT. An assessment based on an expert report may supplement that evidence, but may not replace it.
Yep.
So we say that this is entirely consistent with our case and confirms that it's for the taxable person to produce that objective evidence, but that may not be in the form of the invoice.
Yeah.
And then before we leave Verdun, can I briefly show you 74 of the AGO, which is on page 456. Where he describes Reisdorf there as authority.
Sorry, where are you looking at?
Page 546.
546, yes.
Paragraph 74.
Yes.
He explains what he regards Reisdorf as authority for, and that's the proposition that in the absence of a valid VAT invoice, a taxable person can provide other cogent evidence that the transaction took place. In other words, that the substantive requirements are met. And we say that the upper tribunal misinterpreted Reisdorf.
So, just before we go on, 41 of Verdun, which is what you were referring us to, which you said supports your proposition, that the tax authorities cannot refuse the right to deduct on the ground that an invoice doesn't satisfy the conditions required by Article 226 and 227, if they have available all the information to ascertain whether the substantive conditions of that right are satisfied, which you say is your proposition.
Yeah.
They refer back to Barley. Barley's 42 and 43.
Yeah.
But go back to Barley's 42 and 43, and hey-ho, we're into that same reference back to, amongst other things, Polski, paragraph 43, which is the point. I mean, there are other cases, I don't think, which we've seen, but we're back to Polski, paragraph 43, which is dealing with additional requirements over and above
what's in 226 of the
Yes,
directive.
but it's also drawing that distinction between formal requirements
Yeah.
and substantive requirements, and that is how it has been applied by the court in subsequent cases,
Yeah.
and not on just the narrow Polsky point.
Okay.
Since the upper tribunal's decision, there have been some further decisions of the Court of Justice. The first is Ferrame, which is at tab 27.
This is another post-Brexit decision.
So this is 11th of November 2021. So that's post IP completion. And in this case, the deduction of input tax was denied because the invoices named a fictitious supplier, and the court proceeded without an AGO, and we can pick it up at page 564. So at 26, again, the now familiar distinction between the substantive requirements of 168 and the formal requirements of 178 and 226. And then at 27, it says it follows that the naming of the supplier on the invoice relating to the goods or services on the basis of which the right to deduct VAT is exercised is a formal condition for the exercise of that right. By contrast, the status of the supplier of the goods or services as a taxable person is among the material conditions for the exercise of that right. And then
When they say at 26, the right to deduct VAT is subject to compliance with material as well as formal conditions, surely they should have said compliance with material rather than formal conditions.
sorry, which paragraph were you in?
26, the one start of what you just asked us to look at. I think. Sorry, did you ask us to look at 26? They talk about the right to deduct being subject to material as well as formal conditions. Your proposition is that they're subject to material, but not formal conditions.
Well, so what the court is doing there is setting out the requirements of Article 168 and the requirements of Articles 178 and 226, and then it's going on to explain how those requirements interact.
And by material, they mean what other cases are called substantive.
Substantive, yes.
Yeah.
So then at 31 and 32, the court repeats the fundamentality and function of the right to deduct. At 33, it records that the right to deduct must be allowed if the substantive conditions are satisfied, notwithstanding any failure to comply with some of the formal requirements. And then at 34, it confirms that if the authorities have the information necessary to confirm that the substantive requirements are met, then they cannot impose any additional conditions upon the right to deduct. Then at 36, the court explains that the position may be different where non-compliance with the formal conditions effectively prevents the taxable person from establishing that the substantive requirements are met, and we would regard that as another an exception to the general rule. And then at 38 and 39, the court repeats that the tax authorities cannot confine themselves to the invoice, but must look at all the evidence adduced by the taxpayer. And it's for the taxpayer to produce objective evidence to demonstrate that the substantive conditions are met. And then at 40, the court repeats that the right to deduct is not dependent on the taxpayer having carried out checks in particular as to the supplier's status. And then at 43, it explains that whilst it's for the taxpayer to establish that the supplier has the requisite status of taxable person, that may be something which is apparent from the circumstances of the case. And then at 49, it says the court has repeatedly clarified in situations where the material conditions of the right to deduct are met, that the taxable person cannot be refused the right to deduct unless it is established on the basis of objective factors that he or she knew or should have known that he was participating in a transaction connected to such a fraud. and then in 49, it's incompatible with the rules governing the right, that right to impose a penalty in the form of refusal of that right on a taxable person who did not know and could not have known that the transaction concerned was connected to fraud. And then that was followed up shortly afterwards by Kenwater, and Kenwater, that's over the tab. Again, the court proceeds without an AGO, and like Ferramay, the issue in Kenwater was with the supplier who was not the true supplier. And then at 24 through
Well,
to...
in Kenwater, the supplier could not be identified, I think.
Could not be identified, yeah.
So you have no idea who the supplier is.
Yeah.
They still said you might be able to deduct.
Yeah. So
If you don't know who the supplier is, ex hypothesi, you haven't got his VRN.
yeah, exactly. So, so essentially, in Kenwater, the court applies that same dicta from Ferramay, and we see that at 24 through to 38. And then at 39, apropos of the point that the supplier's status may be apparent from the circumstances of the case,
Yeah.
it says that is so in particular where it can be inferred with certainty from the factual circumstances such as the volume and price of the goods or services purchased that the supplier's annual turnover exceeds the VAT registration threshold, with the result that the supplier necessarily has the status of taxable
You say
person.
that applies directly to Tarbridge.
Yes. And then at 40, to deny a taxable person the right to deduct VAT on the ground that the true supplier of the goods or services concerned has not been identified and that the taxable person has not proved that the supplier was a taxable person, when it clearly follows from the factual circumstances that the supplier necessarily had that status, would be contrary to the principle of fiscal neutrality and to the case law.
That's why I thought Kenwater was your best case.
Yes.
And at 29 of Kenwater, again, it refers to, I mean, this is your proposition, you can have deduction of input tax if material conditions are satisfied, even if the taxable person has failed to comply, it says, with some of the formal conditions, which is the language we see all
Over
the
and
time.
over, yes.
Over and over and over. In fact, you'd say it's failure to comply with any of the formal conditions. You just don't need them.
Yeah, well, the court has not indicated that there are some formal conditions which are indispensable.
The origins of all this, those wording, some of, goes all the way back to that case where the actual issue was you can't impose conditions over and above what's in Article 226, 6 and 7. So, I mean, is your submission that whatever the origins of the proposition, even if it was, let's say for the sake of argument, in a case in which the actual question was, can a national authority impose conditions over and above what's set out in the directive? It's been misinterpreted or interpreted, however you want to put it, sufficiently widely now that it actually covers the entirety of what is actually in the directive as a requirement of the invoice. So now, in effect, the court has written out of the requirement to recover any formal requirements.
Yes, I mean, well, our case is that the jurisprudence of the court has clearly evolved through that time, and you have that principle.
Can they do that?
Starting, they depart from their decisions without saying that that's what they're doing. So
I mean, some of the earlier points, the cases made the point. You can't, if the directive's there, says it's a requirement, you can't say it's not. I think I saw that in one of the decisions. But in fact, that would be the effect of the recent decisions, is that actually what are stated to be requirements actually aren't really requirements at all.
yeah, I mean, I think as an Anglo-Saxon lawyer, you something jars, doesn't it, with you when something is a requirement, it feels mandatory. But that, we say, is not how the court has approached this, and it has said over and over again that if the formal requirements are not satisfied, the right to deduct must be allowed, if the substantive requirements
Yeah.
are met.
Well, it keeps, in fact, repeating the rubric, some of the formal requirements.
Yes.
And in fact, the some that they were originally talking about were those which were imposed by the national legislature over and above what's actually in the directive. And I think you're saying, in fact, we've got so far as to say, actually, even if you don't have what's required in the directive, you can still claim because if you satisfy the material conditions.
Yes, exactly.
So however the court's got there, it's got there, and you say that's good enough.
Yes.
Yeah.
So, so there's also a couple of domestic cases which...
Just before we leave the EU cases.
Yeah.
Chemwater bases itself very squarely on Ferromet. I think that's the only case that they cite.
Yes.
And Ferromet, as we can see from page 561, was a reverse charge case. Paragraph 12.
Yeah.
So it was a case in which there were no requirements, formal requirements in the PVD. Because it was a 178F case.
Yes. Yes.
So in applying Ferromet in Chemwater, which appears to have been a case which was subject to 226, how did the court manage to simply apply a reverse charge procedure case with no requirements to one with 226 requirements?
Well, the court is saying in Chemwater that the same principles apply. You have your substantive requirements of the right to deduct, and then there are formal requirements around documents and so on. They're not prescribed in the reverse charge case, but
no, they're all national.
They're all national, but they stem from. I'm not sure we've got the provisions, but essentially the directive leaves it to the member state to specify, and I think I'm right in saying that in the UK, under the reverse charge, the invoice is the same. It contains the same requirements as a regular invoice. So I don't know what the position is in other member states, but the directive essentially leaves those formal requirements, the specification of those formal requirements to the member state, but they are nonetheless formal requirements, and the court is drawing that distinction.
All right. Now, next question. I may not want to deal with it right now. What is the status of Ferromet and Chemwater, bearing in mind they are post-IP implementation day cases?
Yeah.
As I understand it, we are not bound by them, but we may have regard to them.
That's exactly it. Yes, they're not retained EU case law under, I think it's section 6, is it? So they're not binding on you, but we say persuasive.
Just out of interest in Chemwater, you at paragraph 27. It says, in accordance with the settled case law of the court, the right of taxable persons to deduct the VAT, etc., is a fundamental principle. As the court has repeatedly held, the right of deduction is an integral part of the VAT scheme, and in principle may not be limited if the material and formal requirements or conditions to which this right is subject are respected by taxable persons wishing to exercise it. It's not quite right, is it?
Sorry, I missed the
paragraph
reference.
27.
Thank you.
It says there that the principle may not be limited if the material and formal requirements or conditions to which this right is subject are respected by taxable persons wishing to exercise it. They seem to think that that comes from Ferromet, and that suggests that they do think that formal requirements have a...
They're saying in 27 that if you meet the substantive requirements and you've got your VAT invoice, you get your deduction. But then when you read on, it's making clear that in the absence of satisfaction of those formal requirements, the right to deduct must be allowed.
Well, if some of the formal conditions are satisfied, are not satisfied, and then in 30, consequently, they say, where the tax authorities have the information necessary to establish that the material conditions have been satisfied, they cannot, in relation to the right of the taxable person, impose additional conditions which may have the effect of rendering the right ineffective for practical purposes. The additional, you read that as saying, meaning additional to the material considerations. The question is whether it actually means additional formal conditions over and above that which is in the directive. It depends if you track back through Ferromet and the case law cited in paragraphs 33 and 34 Ferromet. Again, it's this point that I was raising with you a few minutes ago. You say it's actually any formal requirements at all, because in fact you only need to satisfy the material conditions.
Yes.
It's a very odd use of language, if that is what is meant. It's talking about additional conditions which are imposed by the national authorities. I mean, that's not a very apt way of describing a requirement, a directly effective requirement of the PVD itself, isn't it?
Well, it's saying that the member states can't put in place any additional hurdles beyond.
As a matter of domestic law.
Yeah.
We're dealing here with something that's in the PVD itself.
Well, we are, but the court is just explaining it's not. Those are the requirements, the substantive requirements of 168, and nothing further may be added to them.
Yeah.
So that's our case in a very long-winded odyssey through the case law. So there's two other domestic cases which are featured in the discussion. The first is ZipVit, which is in the first volume.
Well, in effect, you say ZipVit's been overtaken by events. See Ferromet and Cantor.
Yes, we say two things about ZipVit. We do say that there are numerous references in the judgment in ZipVit to payment of the tax by the supplier, and we say that that cannot be what was meant in ZipVit. Those observations in ZipVit are made in the specific context of the circumstances of that case, and the issue for ZipVit was no VAT had been charged to it, and so it had not paid any VAT. And essentially, the Court of Justice said, quite right, there's no input tax due or paid here, and that's the end of it. Yes, ZipVit essentially has been superseded, we say, by Verdun and Ferromet and Chemwater, and also by the Court of Justice's own judgment in ZipVit, where it makes clear that ZipVit didn't get home on the logically prior issue. Then there is also the Royal Mail decision, and we can just skip straight to the Court of Appeal, which is page 162.
Page 162. I've got mine at 269.
So I'm so sorry. I'm in. That's Man. So if we go to one.
You're really looking at Mr. Justice Mann now, are we?
No. I don't think we need to. It's paragraphs 91 and 90 to 93 of his judgment, which are picked up again in the Court of Appeal, and we can start that on 292.
Yes, I think you said that Mr. Justice Mann had correctly interpreted ZipVit.
Yes, exactly. So you said that he correctly interpreted it, and then at 294, at 106, the court concludes that the primary purpose of requiring an invoice was not to protect the recipient of the supply, but to enable the tax authorities to monitor the operation of VAT. That is, in essence, an administrative function entrusted to HMRC. The effective ability of the recipient of the supply to exercise its right of deduction is given by its ability to provide the tax authorities with the necessary objective information, otherwise than by means of an invoice, if it has in fact paid tax. So we respectfully agree with that summary, that the effective ability of the recipient of the supply to exercise its right of deduction is given by its ability to provide necessary objective information that the substantive requirements are met. And then, as I've noted, so ZipVit, the court essentially decided it on the due and paid issue. It didn't then go on to consider the invoice issue. And for your note, the court's judgment it's paragraph 43 on page 291. Page 610 of the hard copy bundle, and then in
well, the CJEU didn't decide the invoice point, but of course it was dealt with very fully by the Advocate General's their opinion in terms which very much echo the approach, as it happens, which this court took in ZipVit. That, as you say, that's interesting but irrelevant.
Yes, yes. So the court says at 43 it's not going to answer that question. And likewise, the Supreme Court declined to explore the invoice issue. And for your note, that's page 312, where the Supreme Court's note dismissing the ZipVit appeal, and at 33 they say that it's unnecessary to consider the invoice issue.
So the AG Cocotte is very clear in ZipVit at 48 and 49. She says either the right of deduction can be exercised on the supply of the goods, in keeping with Article 167, in which case the only decisive factor is whether, despite the error, that was included, or it depends on possession of an invoice. I consider the second approach to be correct. That's obviously wrong.
On our case, yes. So, so those are the relevant authorities. And if I may, can I hand up a summary that we have produced, which we say are the relevant principles. So those are the principles that we say apply, and we say that applying those principles to the circumstances of the present case, the appellant must be allowed its right to deduct. Where the upper tribunal went wrong was in its summary of the relevant principles at paragraph 161. And if I can briefly run through those.
I'm sorry, I was skim reading what you have given us. Sorry, what you...
That's okay. I'm going to 161 of the upper tribunal's decision.
Paragraph 161 on page.
Paragraph 161 of the upper tribunal.
Yes, this is their summary. Yeah.
This is their summary, and they apply these principles. And essentially, the reason why the upper tribunal got the answer wrong in our submission is that it summarised the principles incorrectly. So, subparagraph 1, we say it did get that right, so we take no issue with that. In subparagraph 2, We say that the upper tribunal's summary here materially overstates the position, and what Reisdorf actually says is that the exercise of the right is normally dependent on possession of the valid VAT invoice. We say that it's the guaranteed ticket of admission, but it's not the only means of entry. So we say that the second proposition is incorrect. It's not mandatory to hold a valid VAT invoice in order to exercise the right to deduct.
It's quite a curious use of the expression sort of ticket for entry. I mean, if in fact you can get crash the party anyway.
Well, that's what the court says. It's the ticket of entry until you satisfy that the substantive requirements.
You get crash. I mean, what started as a ticket for admission has actually become you just don't need a ticket. Actually, you can just if you can show it otherwise.
It's the guaranteed seat. It's the guaranteed seat. Perhaps you turn up at the theatre and you can stand at the back. I don't know. I mean, you know, it's.
Do you know who I am?
It's not that you're there. You're in the right place, but you don't have your guaranteed seat, and you can say that is, you know, as I say, as an Anglo-Saxon lawyer, the word shall or requirement or whatever, it does feel very mandatory, but that is not how the court has approached it.
So the court's moved on. Okay.
So the third proposition, we say that also materially misstates the position. When the upper tribunal says that member states have a discretion to accept alternative evidence, which establishes that the substantive conditions have arisen, and that the formal requirements have been sufficiently satisfied, what it should have explained is that, or what the member states in fact have, is a discretion as to what alternative evidence they will accept as satisfactorily establishing that the substantive conditions are met. Where, however, the taxable person is not in possession of a valid VAT invoice, we say he must be allowed to adduce other evidence. There's nothing discretionary about that. It's mandatory. And that the substantive, and demonstrates that the substantive requirements are met, then the tax authorities must give effect to that right to deduct. So we say this proposition suggests that it's discretionary when in fact there is nothing discretionary about it once they are satisfied that the substantive requirements are met. As for the proposition that the taxpayer is required to show that the formal requirements have been met, we say that there is no authority for such a proposition. Quite the reverse. We say that the court has repeatedly described the requirements of a VAT invoice as formal requirements, and there is no substantive requirement to produce compliant invoices. In subparagraph 4, the upper tribunal says that the taxpayer can be denied the right to deduct in circumstances where he has not subsequently corrected invoices or provided sufficient alternative evidence of the formal requirements. And again, we say it's simply no authority for such a proposition. Indeed, the court in Ferramay and Kenwater has indicated that the tax authorities are required to look beyond the invoice and take account of any additional or alternative evidence demonstrating that the substantive requirements are met. Nowhere has the court said that the taxpayer must correct the invoices or provide alternative evidence of the formal requirements. The second part of subparagraph 4 is, with respect, confused. If the substantive conditions are satisfied, then the Court of Justice is clear. We say the right to deduct must be allowed, save in those 4 exceptions set out in paragraph 9 of our hand up. And we say that the insurance function to which the upper tribunal refers there is not about verification and monitoring per se. It is, as the Advocate General in Barlas explained, about ensuring that the tax authority can recover by way of output tax from the supplier the same amount as is claimed by way of input tax by the recipient. And so as a result, all that the insurance function requires is that the tax authorities can establish the amount of VAT due and from whom to collect it. In other words, the identity of the supplier. And moreover, in Barlis, as the AG explains later on in her opinion, once it's no longer in doubt that the substantive requirements are met, the monitoring function of the VAT invoice falls away. It's OTOs. Then the fifth proposition suggests that in the absence of a valid VAT invoice, the right to deduct is dependent upon the production of corrected invoices, or establishing that there's been no loss of tax or no impediment to the tax authority's monitoring function. And again, we say that there is no authority for that proposition. If the right to deduct was dependent on the production of corrected invoices, then the court would surely have said so, in particular in Verdun. Similarly, as far as the risk of tax loss is concerned, the court has explained in Collet that this is only relevant if the taxpayers acted in bad faith. And as for any impediment to the tax authority's monitoring function, again, as the AG in Barlis explains, there is no such impediment once it's established that the substantive requirements are met. And then sub 6, we say, again, no authority for the proposition that certain of the formal requirements are indispensable. In particular, we say the court's observations in Petroma are specific to the circumstances of that case, whereas in this case, it's common ground that the substantive requirements were established prior to the decision to deny the deduction. And indeed, if what the upper tribunal says in subparagraph 6 is correct, then why has the court never indicated which of the formal requirements are, in effect, substantive requirements? And one would have expected them to do that, at the very least, in Verdun. The highest that the court has put it is that the VRN, in this case, is an important element in the monitoring of the tax. It doesn't say that it is a necessary component of the substantive requirements. So those are the propositions which feed into the first of our ground of appeal. I'm looking at the time, and I've gone over a little bit. I can wrap things up very quickly in 5 minutes on the other side if I can seek her indulgence.
Yes, so you want to break now, yeah?
If I may, I can
right.
consolidate what I've said and
come back at
be much more
2:05.
efficient. Thank you.
All rise.